For all the Jural Assemblies 55 Municipal Courts, Death and Taxes. April 27, 2019 by Anna von Reitz. The Municipal United States Government operates exclusively under Title 50 of the Territorial Federal Code, and has never adopted any other title of federal code. The internal affairs including the financial and political affairs of this creepy warmongering state within a state perched on our shores and ruled over as a plenary oligarchy by the members of the Territorial Congress, are not open to general public view. Last time I looked, you could buy your own copy of the Washington, D.C. Municipal Code for about $800. It includes such nuggets as the statutes they use to claim that we are legally dead and set up offshore corporations in our names, to sell child labor contracts, to launder money, to create giant slush funds, and for other purposes. The Municipal United States Government styles itself as a Roman-style republic. This is the source of the Roman fasces, a bundle of sticks emblem that you see in the Capitol Rotunda and elsewhere. Aside from the lies that these monsters have told about us to enrich themselves, they have no jurisdiction related to any living American, yet they contrive to create and enforce the lion's share of the false claims in commerce that are brought against our good names and estates. These false claims are brought in municipal courts, and it is important for you to realize that everything about municipal court is the realm of the dead, literally. No living men appear in a municipal court. Ever. What appear there are incorporated entities and the officers of incorporated entities, and rarely, a corporate entity which is not incorporated, but nonetheless, also a dead legal fiction entity. How can you tell whether you are in a municipal court or a territorial court? The municipal courts are the special province of incorporated entities, which are indicated by the use of dog Latin. They use the all-capital letters conventions of Latin to write what appears to be English, and isn't actually, just like the thing bearing what appears to be your name isn't you. It is all built of deceptions within deceptions, designed to confuse identities and issues, so when you go into one of these courts, you must be firmly grounded in exactly who you are, who they are, and what your relief and remedy is. When you see the name of the court written in all capital letters, you know it is a municipal court. And you know that the only relief to be found in a municipal court is 50 U.S.C. Appendix, Section 7, C, and E. Trading with the Enemy ACT of 1917 ACT October 6, 1917, ch. 106, 40 Stat. 411, page 19, Title 50, Appendix, War and National Defense. Section 7, c. The sole relief and remedy of any person having any claim to any money or other property heretofore or hereafter conveyed, transferred, Section 8 assigned, delivered, or paid over to the alien property custodian, now the U.S. Attorney General, or required so to be, or seized by him shall be that provided by the terms of this Act, said sections, and in the event of sale or other disposition of such property by the alien property custodian, shall be limited to and enforced against the net proceeds received therefrom and held by the alien property custodian or by the Treasurer of the United States. So, when you have to visit a municipal court, this, the foregoing, is the sole relief and remedy for your lawful person. The probate of your estate can never be closed, and all the profit that these monsters seized upon, all the state trusts they created, all the resources they commandeered, have to be reclaimed and redeemed through the office of Alien Property Custodian, which office was closed and its functions transferred to the U.S. Attorney General. Yes, we have more important business to discuss with Mr. Barr than you might suppose. When we visit one of their municipal courts, we do so as lawful persons, that is, via our reclaimed and reconveyed trade names, and the only thing we say to them is that we are claiming our sole remedy and relief guaranteed under Title 50 as cited above. We then proceed to tell them what we want: our land and homes and perfected titles, our trusts, our gold, our silver, and all our material and immaterial property assets and interests, free and clear of any debt or encumbrance. Please also note Section V of the Trading with the Enemy Act, which documents the official end of the Second World War. V. Termination of state of war, cessation of hostilities. The cessation of hostilities of World War II was officially proclaimed by the President of the United States, Proclamation No. 2714, December 31, 1946, 12 FR 1, 61 Stat. 1048, in the following language: Now, therefore, I, Harry S. Truman, President of the United States of America, do hereby proclaim the cessation of hostilities of World War II, effective 12 o'clock noon, December 31, 1946. This is the missing sunset clause that is applicable to end the victory tax, by which millions of American state national civilians were ensnared into paying federal income taxes voluntarily to help the war effort, and then were simply coerced and extorted into paying federal income taxes forever afterward via the false presumption that they were volunteer British merchant marine warrant officers known as withholding agents, and that no specific sunset clause ended this arrangement. Well, here it is, tucked away in Title 50, for evidence that no actual state of war allowing American state nationals to pay federal income taxes exists, very handy for claims against the Commissioner of the Internal Revenue Service. Here is also the 1934 amendment to the Trading with the Enemy Act, which sets aside any statute of limitations to collect property lost prior to 1934, which includes the state trusts, gold, taxes, all from their perspective, war profits that we, American state nationals, are heir to and owed. An ACT to amend Section 24 of the Trading with the Enemy Act, as amended. Be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that Section 24(b) of the Trading with the Enemy Act, as amended by the Settlement of War Claims Act of 1928, approved March 10, 1928, is amended by adding at the end thereof the following: notwithstanding the expiration of any period of limitation provided by law, credit or refund of any income, war profits, or excess profits tax erroneously or illegally assessed or collected may be made or allowed if claim therefore was filed with the Commissioner of Internal Revenue by the alien property custodian on or before February 15, 1933. Approved, June 18, 1934. And here's the annotation for the above. June 18, 1934. 8. 852. I. Public, No. 374. Trading with the Enemy Act, amended. Volume 42, p. 1516, Volume 4, p. 277. Credit or refund of any income, or war profits, erroneously assessed and collected, authorized. From the foregoing it is pitifully apparent how grotesquely evil and corrupt the politicians, heads of political lobbies, have become, and the urgent need for the people of this country to stir their stumps and put an end to this criminality and usurpation under color of law, warmongering, racketeering, and extortion.